We're now looking at the idea that an agency, a principal, may be responsible for the torts committed by an agent. The principal is, of course, responsible in contract, but there is a different liability rule for the tort context. When we look at the idea of a principal being liable for torts committed by an agent, as we discussed in class, control is really the center of the area where we will find liability. I referred to this as the bubble of the agency relationship. Just because someone is the agent of someone else doesn't mean that the principal should or is automatically liable for everything that that person does. I think an example that I've given before is if I hire someone as my research assistant and then they go home and kick a puppy, it really should have nothing to do with me, that I would be responsible for that unless it's part of their job to engage with puppies or do other crazy behavior. Or if I tell them directly, oh, as part of your research assistant duties, please go home and kick a puppy. So we're really looking at where the harm-causing conduct fits into the agency relationship. And if it does fit within the bubble, as I call it, of the agency relationship, then it may be appropriate for liability to affix to the principal. So we're going to look at a few rules that are the liability rules for creating liability for a principal when the agent commits a tort. Okay, the first place that we're going to start is at 2.04, and of course I am referencing the third restatement on agency. And at 2.04 we see a rule called respondeat superior. And the idea behind this rule is that an employer is subject to liability for torts committed by employees while acting within the scope of their employment. We also see this very much echoed in 7.071. An employer is subject to vicarious liability for a tort committed by an employee acting within the scope of employment. So it's mentioned twice. So of course, similar to the last part that we looked at, we need to break down this liability rule to understand the constituent elements so that we can apply it correctly, because application is where it's at. So when we look at this particular rule, the things that really stand out as needing some sort of clarification or definition is who is an employer versus an employee, and what's the difference between a principal and an employer, or an agent and an employee. As I have said before in class, all employees are agents, but not all agents are employees, which means that all employers will be principals, but not all principals will be employers. That's the flip side of the coin there. And we also have to look at scope of their employment. So scope of the employment is really the big part of the bubble that defines the territory that we are in when we're looking at liability here. So, thankfully the restatement in various other places gives us a bit of guidance here. That 7.073, when we look at it, it states for the purposes of this section. So it does confine it to this liability rule. An employee is an agent whose principal controls or has the right to control the manner and means of the agent's performance of work, and the fact that the work is performed gratuitously does not relieve the principle of liability. So what we have here is a conjunctive test, if you will. So both A and B have to be present in order, not even present, both A and B have to be considered in determining whether or not an agency relationship exists. So the traditional idea of us considering that an employee is somebody who is hired by someone and put on either salary or wages and who has set job description, that really doesn't jive with this definition. There's nothing here that says, well, it has to be formally done, they have to call themselves an employee or an employer, they have to understand that they're an employee or an employer. It just deals with control. And not just a little bit of control, because when we look at agency, a mere principle is created in an agency relationship when we have a little bit of control, the right to control how the agent does the job. So this is an enhanced level of control. So the threshold for finding that somebody is an employee or an employer, if you will, is a little bit higher than just merely principal agent. So the control involved is a little bit more. So they control the manner and means of the agent's performance, or they have the right to control. And we've discussed in past how control versus right to control, you can't escape liability merely by saying, well, this is the end I want, but I'm not telling you how to do it. I'm going to be hands-off. So, oops, I will not be liable. It's my very clever litigation strategy. Wouldn't work. And this does point out that using the usual construct of an employment relationship being in terms of compensation, that's not what we're talking about here. The fact that the work is performed gratuitously does not relieve the principle of liability here. So we can't just look at a formal relationship. We have to look at control, the right to control the manner and means, or who does control the manner and means of the agent's performance of work. So I need you to get out of the mindset that employer-employee is a formalized relationship that has been, you've signed a contract that says, I am your employer and you are my employee. It's not that formal. Okay, another thing that we looked at in the liability rule is scope of employment, the bubble, if you will, the boundary. And 7.072 tells us that an employee acts within the scope of this employment when performing work assigned by the employer or engaging in a course of conduct subject to the employer's control. Okay, so that's kind of broad. Performing work assigned by the employer, yeah, that kind of makes sense. Or engaging in a course of conduct subject to the employer's control. So that's a little bit broader. Here's the end, go do it, great. A little bit more subject to the employer's control, a little less specific. However, I will tell you, I'm not going to get into it in this little snippet, but case law has basically gone in the direction that absent a complete abdication of duties, courts are very reluctant to find that a little side foray by an employee is sufficient to not be within the scope of employment. An employee's act is not within the scope of employment when it occurs within an independent course of conduct, not intended by the employee to serve any purpose of the employer. So again, this is helpful in terms of defining what we need to determine, but we have to look at this in terms of case law, which has been pretty clear that courts are pretty reluctant to let an employer off the hook completely. Let's say that you were, skiing down a hill when you are the chef, and you're going from one chalet to another, and you may do a couple of runs down the hill on your way from one location to another, and you injure someone. And were you skiing for fun? Were you on a frolicking detour? Were you not? Were you on an independent course of conduct, not intended by the employee to serve any purpose of the employer? And we all know how that case turned out. And if we don't, you really ought to read the casebook. So, if it's not in the casebook, I guess I'll be talking about it in class. Now, you'll notice that the previous two things that I read dealt with employee and employers. So, when we look at respondeat superior, it centers on an employee committing acts. So, what about other situations where there isn't an employment scenario? Well, there are rules for that. 7.08, a principal is subject to vicarious liability for a tort committed by an agent. So again, we're back into the ordinary language, principal and agent rather than employer-employee. In dealing or communicating with a third party on or purportedly on behalf of the principal, when actions taken by the agent with apparent authority constitute the tort or enable the agent to conceal its commission. So we still have tort liability for principals, but it's a little bit different if it is a mere principal rather than employer. So we have to have a situation where apparent authority and the actions taken by the agent who enjoys apparent authority constitute the tort, or that apparent authority allows the concealment of the commission of the tort. And we'll discuss this in a little bit more detail in class. Finally, the principal's negligence can also cause liability for that principal for the tortious actions of an agent. If we look at 7.05, 1 and 2, a principal who conducts an activity through an agent is subject to liability for harm caused by the agent's conduct if the harm was caused by the principal's negligence in selecting, training, retaining, supervising, or otherwise controlling the agent. So a principal can't hide behind the fact that, well, I just hired them. You know, they did the tort. It wasn't part necessarily of apparent authority. It wasn't part of what I told them to do. It wasn't part of the ordinary scope of employment. But if I don't do a decent job in training, retaining, supervising, or controlling my agent, I could be subject to liability. And specifically when a principal has a special relationship with another person, there is a duty of care, a duty of reasonable care to that third party with regard to the risks arising out of their relationship, including the risk that agents of the principal will harm the person with whom the principal has such a special relationship. So that basically tells you that a principal who unleashes their agent, if they have a special relationship with a third party, there is a duty of care between that the principal owes to that third party to make sure their agents are not going to harm that special person in the relationship.